Very pleased to have such a distinguished panel to guide us through these contradictions and complexities. Professor Keating, if you could kick us off.
Thanks, Mure. The first thing to try and understand is what we mean by an internal market. This is not a precise legal concept. It's really an economic theory, quite a contentious one, and one that can be interpreted in different ways. But essentially, an internal market means that within a union or within a country, there are no obstacles to the free trade and the free movement of goods, services, people and professional services. That sounds fairly straightforward. In practice, it's really a bit more tricky. There are, of course, no customs duty between member states of the EU or between England, Scotland, Northern Ireland and Wales. So the main focus is about regulatory differences. Do we have different food standards, environmental standards, production standards and so on, which could cause obstacles to trade so that a good made in one part of the UK will maybe not acceptable because the regulations in another part of the UK don't allow it. Now, with regard to most goods and services, this is relatively straightforward. The difficulty comes in defining the limits of the market. What sort of things should be traded freely and what sort of things should be considered matters of public service, should be regulated according to ethical, cultural, environmental or social principles, because not everything is in the market. So should we have the health service there? Should we have education there? There are always some exceptions, and defining those exceptions has been the most difficult thing about the European single market, and has caused an enormous amount of political controversy and litigation. Now, the internal market bill that's before Parliament attempts to produce an internal market within the United Kingdom to replace the European internal market, because once we finally leave the European internal market at the end of the year, there'll be no regulatory harmonization within the UK. So it's an attempt to replicate something that already exists in Europe. Now, there are two ways of dealing with these regulatory differences that might get in the way of trade. One is by having a single set of regulations for the whole of the UK or the whole of Europe. And the other is by what we call mutual recognition. That is, if it's recognizable for trade in Scotland, it would be recognizable in England, Wales and Northern Ireland. The EU uses both of these. And so the UK government is trying to replicate that feature of the European Union to ensure that within the UK after Brexit, there'll be no obstacle to free trade. The difficulty, of course, is precisely in defining those exceptions, because no internal market in the world covers everything. The EU internal market has a very broad clause saying, well, governments can override this principle for public policy reasons to do with culture and environment and social policy, a whole range of things. Within the UK government's internal market bill, the exceptions are much more tightly defined. Yes, the health service is exempt. Yes, social services are exempt. But what about education? What about food standards? It's not quite clear what is exempt and what is not. And this is likely to cause a great deal of difficulty. The other difference between the UK proposals and the European internal market is the mechanisms by which the internal market is defined and maintained. Because within the European Union, we have a role for the European Commission, which is independent of member states and does all the homework and the technical work and proposes regulatory harmonization. And if that has to go into law, it goes to the Council of the European Unions, and all the member states debate it, and a majority, a qualified majority, has to agree. It goes to the European Parliament, and then there's the European Court, which maintains the legal regime, upholds it in individual cases. Within the UK devolution settlement, we don't have those institutions. And indeed, the UK internal market bill, as proposed by the government, says effectively the UK government, with some input from the UK Parliament, will define the internal market itself. It won't cover things that are already exempt from it. There are some exemptions in the white paper, but apart from that, it will be UK ministers that decides what those exceptions are, what goes into those lists, what comes out again. It will be the UK government that monitors the internal market with the help of the Competition and Markets Authority that is responsible to the UK government, and the UK government that will make the regulations. That's really very, very different. And finally, a critical difference between the EU internal market and the UK proposals is that within the European Union, there are two principles, that is subsidiarity and proportionality, which mean that with regard to the internal market, or indeed anything else, decisions must be taken at the lowest level and only taken at the European level if they can't be taken anywhere else. And secondly, proportionality, which is that measures must be only as detailed as is needed to meet the demand. These principles are upheld by the European Court. So one can see where the government is coming from here, trying to retain this idea of getting rid of obstacles to free trade within the UK, I should say, once we leave the European Union. But the implications for the devolution settlement are really quite radically, possibly quite radical, and possibly changing the balance of devolution itself as we've known it for the last 20 years.
Thank you, Professor Keating. And I think I'm right in saying next will be Professor McHarg to go into some of those issues further.
Yes, thank you. So what I'm going to try and do as fully as I can in 10 minutes is to explain the technical operation of the bill. I'm going to focus on the key provisions underpinning the internal market and how they'll be enforced, but if I've got time, I'll try to say something about the aspects of the bill as well. So at the heart of the bill is the so-called market access commitment, which consists of two principles, mutual recognition and non-discrimination, which are obviously very familiar from EU internal market law and internal market regulation elsewhere. Mutual recognition, for those who are not so familiar, essentially means that if a good or a service can be lawfully supplied in one part of the market, so in this case in one part of the UK, then it can be lawfully supplied in all parts of the market, even if it doesn't comply with local regulatory requirements. Non-discrimination means that regulatory authorities in one part of the UK cannot apply rules which treat locally produced goods or services more favourably than goods or services coming in from other parts of the UK. And this applies both to direct discrimination, so rules which expressly treat incoming goods less favourably, and also, and more importantly, to indirect discrimination, so rules which are neutral on their face, but in practice place greater burdens on incoming products or services. Worth noting, though, on the theme of differences from EU law, the definition of indirect discrimination in the bill is different from that in EU law. It requires not only that the rule in question puts incoming goods or services at a disadvantage, but also that it has an adverse market effect. And it's not clear exactly what that will mean. So one key issue is when will these principles apply, and in particular, when will mutual recognition apply rather than non-discrimination? And that's important because mutual recognition has a more intrusive effect on the ability of governments and legislators to regulate their own territories. As I've already indicated, both principles apply to both goods and services. The mutual recognition principle applies essentially to so-called product requirements. So that's requirements which relate to the production, the composition, or the presentation of goods, which, if not complied with, will prohibit the sale of those goods. Non-discrimination, on the other hand, applies mainly to so-called selling arrangements. So that would cover, for instance, restrictions on how and to whom goods are sold, or restrictions on the transportation or storage of goods. Again, the precise boundary between these two things is not entirely clear. For instance, not entirely clear on the face of the bill whether, say, a minimum price requirement would be classed as a product requirement subject to mutual recognition, or a selling arrangement subject to non-discrimination. For services, mutual recognition means that anyone who's authorised to provide a service in one part of the UK is automatically entitled to provide those services elsewhere in the UK, and that also applies to recognition of professional qualifications, The non-discrimination principle then applies to any regulatory requirements affecting the provision of services. As Michael indicated, there are a number of exclusions from and exceptions to these principles. Three major ones I want to highlight. So first, broadly speaking, the market access commitment doesn't apply to public services. There's a long list of excluded services, and the supply of goods in pursuit of a public function, so say the supply of prescription medicines, is also excluded. Secondly, the market access commitment does not apply to regulatory requirements which are in existence before this bill is enacted. So any existing regulatory differences will continue to have effect. However, if there's a substantive change to those rules, they are brought back into the scope of the internal market rules. Again, what counts as a substantive change is not clear. Minimal alcohol pricing currently excluded because it already exists, but what if the minimum price is changed? Would that be a substantive change or not? That's unclear. Thirdly, as Michael said, limited scope for derogation from mutual recognition and non-discrimination principles, but much, much narrower than they are under EU applied to prevent the spread of pests or unsafe foodstuffs or diseases, and in very limited conditions. Direct discrimination can only be justified in response to a serious public health emergency. Slightly more scope for justifying indirect discrimination, but much less than under EU law. And as Michael said, importantly, many of these conditions affecting the application or the scope of the market access commitment are subject to change by UK ministers. Sometimes they're obliged to consult with the devolved governments, but not always. Okay, so how will these provisions be enforced, and how will they affect the competence of the devolved legislatures? The key point to grasp is that the market access commitment will be enforced by disapplication of the rules which are incompatible with mutual recognition or non-discrimination. And this will apply both to primary and secondary legislation, and both to devolved and, with some exceptions, to UK legislation. So in other words, say a trader wishes to sell goods produced in or, importantly, imported into England, and it would be lawful to sell them in England, then any rules which would make it unlawful to sell those goods in Scotland, or which would put them at a disadvantage, a competitive disadvantage, simply won't apply. Anyone with any role in enforcing regulatory provisions will be required to disregard them, and if there's any disputes, then that will go to the courts for resolution. Now, this also means that as far as the devolved institutions are concerned, the internal market rules will operate differently from rules of EU law. Currently, if a piece of devolved legislation breaches EU law, it is simply not law, it is invalid and of no effect. By contrast, devolved legislation which conflicts with the market access commitment will be valid, and it will still be able to be applied to local goods and services, but it will be ineffective in relation to incoming goods and services. And this is what allows UK ministers to say the bill has no effect on devolved competences. But that's not quite true in one obvious and one less obvious way. The obvious way in which it's not true is that the devolved legislatures will not be able to override the market access commitment. The devolution statutes will be amended to make this bill a protected enactment, which the devolved legislatures are not permitted to repeal or modify. And that will contrast with the position of the UK Parliament. So although UK legislation applicable to England will be at risk of disapplication if it conflicts with the market access commitment, the UK Parliament will be able to override it expressly if they want to do so, because of parliamentary sovereignty. The other more subtle way in which devolved competence is altered is in relation to its territorial scope. So currently, laws passed by, say, the Scottish Parliament apply to all of the relevant activity within the territory of Scotland. But under the bill, Holyrood will only be able to legislate in effect for goods produced in or service providers based in Scotland. Although those service providers or producers will in effect be able to carry those regulatory standards with them if they operate in other parts of the UK. So in other words, applicable regulatory standards will depend on where the producer or supplier is based and not on where they're trading. And as Nicola will discuss in more detail, that will make it difficult for the devolved institutions to enforce a particular set of regulatory standards for their own jurisdictions, and it also sets up the conditions for regulatory competition throughout the UK. The other point to make about enforcement is that because the market access commitment does not invalidate incompatible laws, the machinery that's in place for pre-enactment scrutiny of the validity of devolved legislation will not apply. So it will not be possible to, for instance, block the enactment of discriminatory legislation. Relevant regulatory requirements, both on a regular basis, a regular reporting on the state of the internal market, and on request from either the UK government or one of the devolved governments. So a government will be able to request a report on the impact of a provision that it's proposing to enact or has enacted, and also a report on the impact of a provision enacted elsewhere. But those reports will not be binding. So any finding of an adverse impact on the internal market will be for the resolution through intergovernmental processes. Okay, I think I've run out of time, so I will stop there and I can come back to the other provisions if necessary later.
Thank you very much indeed. And finally, Professor McEwen.
Brilliant, thanks. So what I thought I would do is return to where Mure started, in a sense, is to the claim and counterclaim of what this means for devolution. On the one hand, we have the Secretary of State in particular talking about the powers, maybe not using this phrase, the powers bonanza, but that's been used before, about how this strengthens devolution essentially. And then we have the claims of the devolved governments talking about the assault on devolution or the power grab that this entails. So what actually does the bill do? Well, one thing it doesn't do is increase the powers of the devolved institutions. There is a claim to make to say that devolution and devolved powers are enhanced by EU exit, but that claim could be made more of an older piece of legislation, the EU Withdrawal Act from 2018, not this particular bill. In fact, this particular bill in some ways explicitly limits devolved powers over state aids, for example, which is listed, was an area of disputed competence, but in this legislation it is listed as an area that will now be reserved. Some of the other aspects of the bill around enhancing the UK government's spending powers in devolved areas, it could, depending on how it's implemented, also modify at least some of the powers of the devolved institutions. Some things are protected, as Aileen mentioned. The provisions in this bill are forward-looking, so they're not dealing with existing differences and divergences that are already in place. They are about new things that would be introduced. So in some senses you can say that it protects the devolution and the distinctiveness and divergence that is there already, but it would limit it for anything in the future. And also it's fair to say that there's nothing in the legislation with regard to the market access principles that limits the competences of the devolved institutions to pass laws in devolved areas. As Aileen was pointing out, what it does do is it limits the difference that those laws could make. It limits their scope. And maybe if I can just illustrate with one or two examples. So if, for example, the Scottish Parliament was to pass legislation to reduce the sugar content or the salt content in goods as a way, goods produced in Scotland as a way to hope to tackle a public health issue, or the Senedd, for example, would want to promote its sustainability goals by reducing the plastic content in goods produced in Wales. There is nothing in the bill to stop them from doing that, but they couldn't then impose those duties on those regulations on goods that were entering the Scottish and Welsh market. And given the extent to which that happens, then obviously the ability to pursue those policy goals in Scotland and Wales would be significantly reduced because of the mutual recognition principles and, crucially, the limitations on the things that can be exempted from those mutual recognition principles. So it does have the potential to significantly affect devolution in my view. There are some broader effects for devolution that I think are affected by this legislation. One is, if you think about what some of the purposes of devolution were, it was about being able to ensure that there could be institutions, laws, policies that reflect local differences, that reflect local needs, that reflect local preferences in each of the devolved territories. And to the extent that the bill limits the scope of those things, then it will affect one of the central purposes of devolution. The other thing it limits is innovation. So in two ways. In a sense, if you are containing or limiting the extent to which policies may be made or pursued, and limiting the results of those policies, then the opportunities to learn from policy innovation in different parts of the UK may be diminished. And we've seen countless examples of where policies have been introduced in one part of the UK and the other administrations have learned from it, adapted it, decided not to do it. But it's policy experimentation and policy learning has been one of the valuable outcomes of devolution. And that might still go ahead, but in these areas where it comes to policies that are that intervene in the market, then there would be significantly greater limits than we have seen so far. The other way it undermines innovation is because of the way the bill is forward-looking, because it protects and preserves the existing divergences, then it may disincentivize administrations from changing those when they might otherwise be inclined to do so, because to change them or to replace them would then bring them into the scope of the internal market principles. So in a sense, that may be a deterrent to change. A third feature for me is that it reinforces the dominance of the UK government and England, and I suppose in the English market, in the other three territories, and particularly in Scotland and Wales, in terms of the union, in terms of the market. And that's purely because of the size of England in terms of a market producer and a service provider, but also given the asymmetrical effects of the legislation on the powers of the different institutions. So I think that is reinforced by the legislation. And finally, the final effect it does is it diminishes trust further. Trust between the governments in the UK is very low and will be further dented by the process of this legislation. So is there a problem needing fixed here? And is there an alternative way to fix it? Now, I think there probably is a problem. So there is a problem created by the UK leaving the EU regulatory umbrella, and the possibility that that produces greater divergence, and the possibility that that produces more barriers to trade. I'm not convinced that it's a problem that needs such a heavy-handed approach, and I think time would have enabled us to see the extent to which there is a problem that requires some intervention in order to fix it. The devolution settlements already give most of the power over the market and over competition to the UK Parliament anyway, and so there already is protection built into the devolution settlements to minimise market distortions. And the European Union Withdrawal Act also, remember we talked about retained EU law, also preserved a lot of the regulations in domestic law, at least for a while, until freeing up the administrations to find time and space to come together where it was necessary to do so, to have agreed approaches. And they have been doing that. They have been doing that in the area of common frameworks. These are not all in place yet, but there has been progress made in a collaborative way with the governments working together to see where they might need regulatory frameworks or non-legislative frameworks to help iron out any of the barriers, overcome any of the barriers that might emerge. Clearly, there is also an external dimension to this bill, and that's the issue of trade. And quite explicitly, the UK government has said that part of the motivation for this bill is to ensure that it is able to negotiate and implement trade deals with other countries when these include provisions that in the UK are devolved to the other administrations. Now, there is already also power to ensure international agreements are implemented by the devolved institutions. They have that obligation built into the devolution settlement. But there are also other ways, in my view. You could bring them into the room, even the outside room. You can bring them into the discussion in negotiating trade deals without necessarily having to do it in this way. So, final point then, I suppose part of the reason why we think we're having this legislation is also one of the things that is contributing to enhancing, and that's that there is a lack of trust. The UK government sees this as a backstop, if you like, a way to underpin all of the other things that are going on around common frameworks, around intergovernmental relations. And there is an ongoing intergovernmental relations review, which has been making progress behind the scenes to reform the systems that are in place that can support the kind of collaboration and cooperation between the governments. But the very fact of this bill and the way it has been introduced, the way it is being rushed through, in a sense, the parliamentary process, is making it much more difficult, in my view, to come to a resolution in those other areas around intergovernmental relations. But it's in that space, ultimately, where I think these issues should be dealt with. Thank you.
Thank you very much indeed. And maybe if we could kick off the question and answer session with a question that came in before we started, which is to ask whether the Internal Market Bill would prevent the creation of a national care service in Scotland, which is obviously an idea that Nicola Sturgeon has said she is looking to research. I don't know who wants to take that one on.
Well, I don't think it would prevent that, because social care along with healthcare are one of those areas that are excluded from the mutual recognition principles and the service principles in the legislation. Aileen, do you want to add anything?
Yeah, I mean, I'd agree with that. The only thing to bear in mind is that that list of excluded services is subject to potential variation by UK ministers. So yes, I agree that as the bill currently stands, it wouldn't prevent it, but we obviously have no guarantees about what might come out of or go into that list of excluded services in future.
But perhaps if I could follow up on that, actually, Aileen, you mentioned the minimum pricing of alcohol and that even a price change could potentially trigger a challenge under the bill. Would similar policies in the future be impossible?
So the question of how alcohol minimum pricing is classified, whether it's classified as a product requirement subject to mutual recognition or a selling requirement subject to the non-discrimination principle, would be absolutely crucial there. Because if it's mutual recognition, then a requirement to sell at a particular minimum price couldn't be enforced against incoming products. If it's classed as a selling arrangement subject to non-discrimination, then you have to go through that process of establishing that it does in fact discriminate, and that it can't be justified in pursuit of a legitimate aim. So I think it really is a crucial question in relation to that particular issue.
Thank you. We have a question.
Can I just clarify there, Mure? It wouldn't, in any case, it wouldn't be that the legislation would be impossible. The legislation would still be possible. It's just that its reach would be challenged.
Understood. Thank you. A question from attendee. What do you think the bill means for the future of regional funding? By which I think we mean the EU support funds, which the government in the bill now says it wants to be able to, well, it says it wants to be able to spend basically where it likes. Who would like to take that on?
Yeah, could I do that one? We don't know what's going to happen to this funding, but the UK government is proposing something called the Shared Prosperity Fund, which would allow it to spend in areas of its choice. Now, that is clearly linked with this provision in the bill that says that UK ministers can spend in devolved areas. It gives them a general power to spend in devolved areas. Probably this will allow them then to use this money to spend in devolved areas. It's already started doing this with city deals and various other kinds of things. So yes, how much further that would go, we don't know. It's been a great concern in Canada, for example. The federal government has been starting spending in areas of provincial jurisdiction, thereby overriding the priorities of the provinces. This gives the UK government ministers a very general power to do that. And once again, we don't know whether this power is going to be a very narrow one, just to spend that Shared Prosperity Fund, or whether it is part of a general move by the UK government to spend in devolved areas in order to raise the profile of the UK government in Scotland.
Thank you. Another one from the attendees. Does the bill limit the keeping pace power conferred to Scottish ministers by the revised Scottish Continuity Bill?
Shall I take that one? I mean, the answer is, as with everything, it doesn't affect the power on its face. So it won't restrict on its face the use of that power insofar as it's within devolved competence, but it will limit the effect of any rules that are, any EU rules that are incorporated via that mechanism. They won't be able to be applied to incoming goods or services. So, you know, in these circumstances, if we assume that the rules being implemented under that keeping pace power are going to be relatively high, you know, relatively high regulatory standards compared to elsewhere in the UK, what the Scottish Government will be doing if it chooses to use that power is potentially placing Scottish-based producers at a competitive disadvantage. Now that might be a price that is considered worth paying. We know that there is a political background to that keeping pace power. It might be a price that's considered to be worth paying. On the other hand, it might not. So again, the difference, we have to stress this distinction between its legal effect and its practical effect.
Another question then, what avenues are available to the Scottish and Welsh governments to push back on these changes to the devolution settlement?
Shall I take that one? So the legislation is subject to the Sewell Convention, and in the past, the devolved governments have been able to shape changes to legislation by effectively using intergovernmental forums for that purpose, and also the Welsh Government in particular has been quite effective in nurturing its relations in the House of Lords, where a lot of the scrutiny is likely to take place. The Sewell Convention does not give them a veto over aspects of legislation that affect devolved competence, but in the past it has given them some influence over the content of that legislation. I've said in the past at least twice in this little contribution, because the Sewell Convention has been tested and found wanting, in a sense. In a way it worked as long as nobody really quite pushed it that far and nobody really tested its boundaries, but we know from the Supreme Court that it doesn't have a legal effect, and its political effect has been, I think, somewhat diminished during the Brexit process by the fact that that the UK legislation on Brexit-related issues has proceeded without the consent of the devolved legislatures, including those areas that affect their competence. So it is limited, but the influence is political rather than legal.
For a question on Northern Ireland, actually a couple. One is what engagement has the Northern Ireland executive had with the other devolved administrations in response to this bill? And I wonder if we could talk a little bit about what the view from Northern Ireland is about it, and any implications outside of the direct ones on the Northern Ireland Protocol that it would have for devolution to Northern Ireland.
I don't know who wants to take that one. I don't. Yeah, you go ahead, Michael.
Okay, there are implications for Northern Ireland, because Northern Ireland, under the withdrawal agreement, will, to a large degree, align with European regulations. Now, clearly, it can't align with European regulations while allowing mutual recognition for UK regulations. If something is approved in England according to this bill, it's saleable in Northern Ireland. According to European law, it still has to conform with the Northern Ireland regulations. Now, there's a separate bit in the bill about Northern Ireland. It's not terribly clear to me, but there's a clear contradiction between the logic of those two things, and so there will be something different. Now, the UK government and the EU differ in their interpretation of the Northern Ireland Protocol. They always did. There was an ambiguity there. Issues could arise there. In spite of the Northern Ireland Protocol, there could be issues there. As far as the engagement of the Northern Ireland executive with the process is concerned, it was out of action until a few months ago, and so Northern Ireland has not been involved or Northern Ireland politicians have not been involved in this process the way that Scottish and Welsh politicians have, but also in the elaboration of this particular piece of legislation. Since the general elections, none of the devolved governments have been involved. Yes, they have been involved in the so-called frameworks programme, which addresses similar kinds of issues, but this particular bill is a unilateral product of the UK government, and the Scottish and Welsh governments have made very clear their unhappiness about that process.
Well, a follow-up here on the question of UK government's ability to spend in the devolved nations, and does the bill expand the reach of the UK government to fund big infrastructure projects, such as an expansion of the M8, without, even if they're not supported by the devolved government?
Can I answer that one? So the bill extends the power of the UK government to fund various issues within devolved competences. The general rule is that the UK government has no power to interfere in any matter of devolved competence unless it is given specific power to do so, and currently it only has very limited ability to spend in devolved areas. So this dramatically expands the scope of its spending powers. However, the practical implementation of projects that the UK government might want to support will still in some respects be subject to various other constraints, and those constraints will vary depending on what it is that it's trying to do. So for infrastructure, of course, there is still planning processes to go through, and the Scottish government has obviously the key role in planning decisions in relation to major infrastructure projects of that kind. But in other respects, maybe less high-profile respects, it might be possible for the UK government to fund things that the devolved governments have chosen not to fund. But it will depend very much on what they're trying to do.
Can I just add to that, Mure? Just to expand on that a little bit. It's very unlikely that the UK government would fund a motorway in Scotland that the Scottish government didn't want. It's much more likely that it would provide selective funding so as to influence the priorities of the Scottish government. This is already happening with the city deals, where civil servants in both London and Westminster have been involved in the refurbishment of the Perth City Hall, which one might imagine is a matter of the citizens of Perth and nobody else. So it would influence priorities, and this might distort the priorities that are set within Scotland. And it only takes a relatively small amount of additional funding to do that. The European Union does that, of course, itself with the structural funds. It uses the structural funds to lever national and subnational funding. That's much more likely than going in and building projects entirely on its own. But it would affect the balance of power in devolution and the way that devolution works.
Thank you.
I think, sorry, there is some anxiety though in Wales about what it would mean for the M4 Relief Road, and I think it's important to acknowledge that is a project, an infrastructure project the UK government wants, the Welsh government has objections to, and there is some concern that these spending powers would enable that kind of project to go ahead, albeit that, as Aileen pointed out, you would still have planning regulations and so on that would be within devolved competence. Politically, so I think the spending power is difficult for the devolved governments to object to, perhaps depending on the nature of the project. Publicly, more money is more money, and does the public really care who brings in the cash? I'm not so sure that those distinctions are made. So politically, it's a more difficult issue to get across, I think.
Thank you. We have a few questions from attendees who seem still unconvinced about the actual need for the bill, and that's something that was touched on in the initial presentations. But one question asks whether the UK government could have achieved its stated objectives, and it mentions the power of Secretary of State's veto and royal assent where devolved legislation is incompatible with international obligations, and Section 55 SA, which is the power to require action from ministers. And another person has asked in the same vein, essentially someone saying, no, don't quite understand why the bill is actually needed. Could the UK government have achieved its goals without?
Yes, picking up Nicola's cue, and I'm not convinced that this is needed. There are, as you said, all kinds of override powers anyway that the UK government has, but even leaving those aside, there's a process about negotiating policy frameworks amongst the governments of the UK government and the devolved governments that covers many of these same areas. Now, maybe this is just a backstop. Maybe it's something that if those frameworks don't work, we might need ultimately something to deal with unanticipated problems. If these are just minor problems that might come up, this seems to be a very drastic way of going about anticipating those. If it's something bigger than that, then it does affect the devolution settlements. So either way, I'm concerned about this bill. We don't really know what the scope of it is. We don't know how these powers are going to be used. If they're not going to be used, why do we need them? If they are going to be used, then they do raise serious questions about the devolution settlement. There's no reference in this bill to the parallel process of the frameworks, or why they can't deal with it. And that's what's causing a lot of the criticism of this. That these powers just seem to be far too sweeping to achieve what might be a very limited purpose.
Can I just add, so the existing powers are mentioned. One problem with them is that they are not the same across the three devolution settlements. So the power to refuse royal assent to something that interferes with the single market, that applies to Northern Ireland, but it doesn't apply in Scotland or Wales. The other problem with those powers, and the reason why they've never been used, is because they would be, they would be highly politically controversial. So they become very, very hard to use without a political price. So I think what's clever about this bill, if you think that some kind of backstop is necessary for the unanticipated problems, then what this bill does is effectively depoliticise them, because it's not the UK government coming in and saying, no, you can't do that, you can't legislate on that, you can't apply that rule. It's ordinary businesses and service providers acting ultimately through the courts. So that's a much less politically fraught way of achieving that sort of set of backstop guarantees.
Nicola, would you like to add to that?
I appreciate what Aileen is saying about the operation of the bill, perhaps depoliticising it, but that operation would only be on the basis of a bill which is part of a very politicised process. And so I think rather than depoliticise the issue, I think the legislation may in effect do the opposite. And my concern is that it makes more difficult some of the other processes that might have taken some of the heat out of what are, I think, potentially genuine issues here. I think this made the bill and the manner in which and the potential scope of the legislation risks undermining some of the more collaborative sorts of ventures, including common frameworks, that could have dealt with some of these issues.
Thank you. To what extent, sorry, might the bill impact on public procurement? Suggestion of the question. The Scottish Government has said it could be challenged through the use of the non-discrimination rule.
Lots of things for which things will be being procured publicly will fall under that list of excluded services, and the list of services which are excluded from non-discrimination is actually longer than the long list of services excluded from mutual recognition. So I think that would probably limit the scope for impacting on public procurement, but I wouldn't want to give a definitive answer on that.
Thank you. Question following up on the spending powers that the bill gives to the UK government. It asks, if UK government funds something in Scotland, does the bill set out whether and how those funds will be or could be clawed back, for example, via Barnet consequentials? Who would like to take that?
Yes. Well, it wouldn't affect the Barnet consequentials in principle, because they are already laid down by a different formula. But then the Barnet formula itself is not statutory. It's simply at the discretion of the Treasury. So it's entirely up to the Treasury how it wants to interpret that. Yes, it could do that, but it would be unlikely to do that. What it would provide funds which bypass the Barnet formula, this creates transparency. As Nicola said, yes, people will say it's wonderful because we're getting extra money, but if all the bits of the country are getting the extra money, and they will for sure, because if Scotland gets some of this, there will be equivalent spending outside the formula in Wales and Northern Ireland and England. Nobody's getting an advantage at all. It's simply undermining the Barnet formula. And the advantage of Barnet is it comes as a block grant. So it's up to the devolved government to set their priorities rather than having to follow the priorities that are set in England. So my main concern with that is the distortion of spending priorities by taking money which otherwise could have gone through Barnet and putting it through this separate funding mechanism.
Aileen, did you want to add to that?
Yeah, I mean, just to say that the bill itself says nothing about any of this, as you would expect. I think it's in the impact assessment. It states very laconically the Barnet formula will continue to apply, but I think the concern I would have would be that because this is being conceived of as explicitly UK spending, then it is not spending, even if it's in practice spending under this provision is in England, it will not produce Barnet consequentials. because it will be classified. Because we know, that there have been examples of things in the past, the Olympics, for instance, that took place in London, but was classed as UK spending and did not produce Barnet consequentials.
Thank you. And it looks like we've got a really big question to end on, which is, could this Internal Markets Bill be a lever for further constitutional change? And if so, I imagine the questioner would like to know what kind of change. Are we at the beginning of something bigger?
I'm not sure if the bill itself is any more of a lever than, say, Brexit. But I think certainly Brexit has thrown up some challenges for the way that the UK is governed internally. It has raised some questions about the distribution of powers between the different legislatures within the UK, and there appears to be an intention underpinning the bill that this is a way to strengthen the union. And my advice to the architects of the legislation would be that this seems to me to be extremely unlikely to be an outcome of this piece of legislation. There's a very big difference between strengthening the union and homogenizing the union. Uniformity and uniformity of approaches is not necessarily the way that you preserve the union in all its diversity. So whether or not this, alongside other things, is a lever to further constitutional change, that's a matter of politics and political debate and electoral outcomes and all the rest. But I think it's unlikely that the bill will help to shore up and strengthen the union, if that was the intention.
Aileen, did you want to make any points on that?
Well, just to say, I would agree with Nicola. This is a bill which seems to me to be incompatible, as Nicola said earlier, incompatible with the basic idea of devolution, which was to allow the minority nations in the UK to do their own thing in areas which were of particular importance to them. And insofar as this bill undermines that, it does nothing to shore up the union. Whether it's likely to directly undermine the union is a different question. Obviously, it's quite difficult for this kind of bill to achieve much political traction. But if you get to the point where things cannot be done that the people of Scotland or the people of Wales or the people of Northern Ireland want to do and feel strongly about, then that's a different question.
Michael, did you want to add anything to that?
Yes, I was struck that the white paper preceding this bill described the UK as a unitary state. That's an old-fashioned term, because we'd understood that it was a devolved country, a quasi-federal arrangement, or travelling in the direction of federalism. That language itself, it doesn't have consequences, but it seemed to me to be really interesting. Secondly, it does introduce a new principle into the devolution settlement. The original legislation says, here are things that are reserved to the UK, everything else is devolved. It was reasonably clear what the division of competences was and where the Scottish Government and Parliament were free to act on their own. This internal market principle is a cross-cutting principle, cuts right across that division of functions, and potentially could come up in all sorts of unanticipated ways. So its constitutional implications are potentially quite far-reaching.
Thank you very much. We've run just past 5 p.m, so I think it only remains for me to thank our panelists, Professor McHarg, Professor Keating and Professor McEwen, and also to Ellen Cummings and Corey Brown-Swan for arrangements and technical direction. I hope it's been as interesting and enlightening for our attendees as it was for me. So thank you very much again, and goodbye.
Thanks, everyone.